to open today's hearing session, which concerns... Thank you. Sorry, just remember to keep yourself on mute. Thank you. And this hearing session concerns the appeal by Hollistan Renewables LLP against the decision by the Highland Council to refuse to grant planning permission for a wind farm comprising 7 turbines and associated infrastructure known as Hollistan 2 wind farm, which would be located on the Sandside estate approximately 2 kilometres from the village of REAY. Probably most of you know who I am now. I'm Trudy Craggs. I'm a reporter with the Planning and Environmental Appeals Division of the Scottish Government, and I have been appointed to consider this appeal and determine whether or not to grant planning permission. This is a virtual hearing and is being broadcast live. It will be stored as part of the DPA website archives and will be capable of repeated viewing. I have the discretion to terminate or suspend filming if, in my opinion, continuing to do so would prejudice the proceedings in any way. By participating today, you're consenting to being filmed. You're also consenting to the use and storage of these images and sound recordings, and of any images or information pertaining to you contained in them, for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. Further detail on DPA privacy policy can be found on our website. First of all, thank you to my colleagues Graham Masson and Callum Henderson for arranging today's meeting, carrying out testing, things like that. Callum is on the call today. He is doing the streaming and will also step in if there are any technical issues during the course of the hearing. So for the benefit of the live broadcast, can the lead participant for the parties introduce yourselves and those participating today? So I'll start first with the appellant, please.
Good morning, everybody. I'm Robin Hutchison, legal counsel for the appellant. I'm joined today by Ms. Rylett, LVIA consultant, and also in the room but off screen is Angus Elder from the appellant, should he be required.
Thank you. And for Nature Scott, Mr. Finlay?
Yes, good morning, ma'am. My name is James Finlay, Queen's Counsel. For Nature Scott, I have Catherine Harry, who is going to be doing most of the talking, but also listening in, if required, is Debbie Skinner.
Thank you. And for Caithness West Community Council? You're still on mute. Ms. Bundy, you're still on mute. You're still on mute. There we go.
Gillian Bundy, Chair of Caithness West Community Council. We don't intend to lead any evidence today, but we'll certainly watch proceedings with interest.
Okay, thank you. Of course, if you do want to make any comments, you can make comments during the course of the hearing.
Thank you.
And for Rawog?
Good morning, ma'am. Good morning, all. Ian Kelly, planning consultant acting for Rawog. As indicated in the email correspondence, having looked at the agenda, ma'am, I'm perfectly content that it's for Nature Scott to answer most of the questions, unless you have a specific question to put to me. And as with Ms. Bundy, should I wish to interject, I'll obviously put the camera on and put my hand up. But I don't expect to be saying much, ma'am. Thank you.
Well, thank you for that. But again, of course, you can come in with any comments at any point if you feel you've got a comment to make. Okay, so I'll just start with some important housekeeping matters this morning. First of all, for those who are sitting in the same room together, which is the appellant, I just remind you that you must adhere to government guidance on COVID-19 when participating today. Please maintain physical distancing at all times between yourselves and any other hygiene and face mask requirements that you have. As the hearing progresses, if I have any concerns in this regard, I'll bring that to attention, and I may suspend the proceedings to allow you to kind of address the issues if I think there are any. I'd also remind you not to share documents, not to pass documents between yourselves. If you do need time to speak amongst or to confer at any point, I'm happy to have a short adjournment where you can put yourselves on to do that, rather than passing around notes, things like that. For those that are in different rooms, I think that's Mr. Finlay and your team. Again, if you need to confer at any point and would like a short adjournment, I'm happy to do that, allow you to do that by phone or different devices. You can use the phones or devices during the course of the hearing, provided they're not audible, if you need to confer with your team. And again, as I said, if you're not speaking, you can keep yourselves on mute. It just avoids any feedback for others. Okay, so we've set aside a day for this hearing session. Although it's maybe like we won't need all that time, I don't think. There are a few questions on the agenda, but some of them may not require much discussion. Some of them will be quite short and simple. But I'm not trying to curtail the discussion. If we need to go on this afternoon, we will break for lunch between around, say, 12:30 and 1 o'clock at a convenient point. We'll also have a short break this morning just to give people a wee break from their screens as well. So before we move on to the substantive part of today's hearing, does any party have any questions at this point? I can just look at people maybe shaking their heads. That's easier.
Perhaps I could just ask one question and check your expectations on closing are the same as our summer session on LVIA, that it's really for questions rather than closing submissions?
Yes, that's number 16. Yeah, it's just any final concluding remarks you want to make. It's not summing up. It's not bringing your case together. We will discuss the timescale for written closing submissions at the end of the hearing session. So it's really any final points you want to make which you don't think you've made or had an opportunity to make, rather than a general summing up of all your case today. I'm not expecting submissions from the parties at that point.
No, that's clear. Thank you.
And maybe there's nothing, so don't feel you have to say something. If you've covered everything, that's absolutely fine too. It was just any last points you wanted to draw to my attention.
Thank you.
Okay, so just by way of background and for the benefit of those who are actually on the line observing or maybe be patching into the live feed, just to explain that I did hold 2 pre-examination meetings in respect of this appeal, one in May and one in July. And at those meetings, the procedural arrangements were discussed and agreed, and we initially agreed to have 4 hearing sessions. However, on receipt of the written evidence from the parties, it was agreed that there was no need for a hearing session on planning conditions, which would be imposed if I grant planning permission, as these were more or less agreed between the council and the appellant and the other parties. There were minor comments from Nature Scott and the Community Council, but these were minor in nature. Similarly, after reviewing the statement of agreed matters submitted by the council, the appellant and Nature Scott, it was agreed that energy and planning policy should be dealt with by written submissions rather than by way of a hearing. So again, we didn't do a hearing on that topic either. And that left 2 hearing sessions, one on the impacts of Wildland Area 39 and one on landscape and visual impacts. The hearing session on landscape and visual impacts took place in person in Thurso on the 30th of September and 1st of October. And we did an accompanied site inspection before that on the 28th of September, which was very helpful. Unfortunately, due to illness, the hearing session on wildland impacts that was scheduled to take place on the 30th of September could not take place at that time, and I agreed to postpone it and to hold it virtually rather than in person. And that is the session that we're doing today. So we're discussing wildland impacts on Wildland Area 39. The format of discussion is as before. It's a structured discussion between the parties on the matters and questions set out in the agenda, which was circulated, chaired and guided by me. This will enable you to put forward your points, and I should get the information I need to determine the appeal. Any questions of the other party can be asked through me, although hopefully discussion can achieve some kind of flow, although it is sometimes more difficult to do that virtually, but it's still achievable. Please remember that I have to take notes, so please speak slowly and one at a time. And as I just said, there'll be no closing submissions, and we'll speak about the deadlines for those at the end of the session. And just to reassure those who are watching or observing today, although this hearing is limited to the impacts on Wildland Area 39, I will be taking into account all of the written material before me when I reach my decision. So before we move on to the substantive part of today's hearing, are there any procedural matters that any party wants to raise? And I'm taking that as I know lots of shaking of heads, but that's fine. So hopefully we've all got the agenda. Now, Nature Scott kind of anticipated what I was going to do, but I thought at the start it would be useful if the parties give me an indication of the documents you're likely to refer to, just so we can get them to hand. So Nature Scott, Skinner circulated an email this morning with some document references. I helpfully had most of them to hand when I got your email, so that was fortunate. So I now have them all either on my screen or around me when I've got hard copies. I wonder if the appellant had anything they wanted to add to that list just at this point in time, so we could get them to hand. This does not preclude you going to any document at all during the course of the hearing. It's just to avoid people, faffing around and trying to get things up on their screens during the hearing. But as I say, you can refer to any document before me at any point. But if there's anything you want to pick up now that you think we should get to hand, then please do so.
No, I think that the Nature Scott list looked very similar to what we would intend to refer to. Maybe the rebuttals might come up. I don't know if they were on the list or not, but
they're not on the list, but I do have them to hand, which is fine. When I say if as you go through your evidence, there's other documents, then feel free. I've got everything, memory stick and everything here, so I can get to hand whatever I need to do so. So don't feel constrained by this list. But it's just a helpful starting point to make sure we can all get our documents fairly quickly. Okay, make sure no one's got any comments. So if we move on to the agenda. So question 1 is just really for a simple point of clarification to make sure that I've got the position correctly from the documentation before me. From reading the documents, it's my view that it's not disputed that the appellant's assessment is adequate and appropriate, and that there would be significant effects on the wildland qualities. The dispute, in my mind, between the parties is the extent and the importance of those significant effects. And I just kind of people to confirm that my summary, that summary there, is a fair summary of the parties' positions. So we go to the appellant first.
Well, certainly on the first part, yes, agreed there will be significant effects on Wildland Area 39. On the second sentence, so just taking extent and importance separately, I think the appellant's view is that the dispute on the extent of the effects is also probably quite limited. There seems to be essentially broad agreement on what the effects are, subject to a couple of points that will come up in the agenda as we go through. But I think there's broad agreement on the extent of the effects. There probably is a difference of opinion on the importance of the effects, and in particular the sort of overall importance of those effects on the wildland area.
Thank you, that's helpful. Mr. Finlay or Ms. Harry for Nature Scott?
I think Ms. Harry, if you, perhaps I should have said at the outset, if you direct all questions to Ms. Harry to begin with, we're in separate locations, that's just going to be easier. And if for any reason there's a change, I will, or Ms. Harry will alert you to that. It may be I may wish to add something after Ms. Harry's finished, but I'll let you know if I do.
Okay, that's really helpful. But again, you come in if you need to add anything. So Ms. Harry, I'll direct my questions to you in the first instance.
Thank you. Yes, as we raised in our response to the draft agenda, we do agree that the parties dispute the extent and importance of effects on the wildland qualities. We consider that the differences in the importance are important because that's where it may dispute our national interest threshold, and ultimately where Nature Scott decides to object. So in some ways, yes, we do agree with the appellant there that actually it's about the significance and importance rather than the importance rather than the extent is probably the most critical issue.
Okay, that's helpful. I think we're very clear where we are with that, what's in dispute and what's broadly agreed. So if we move on to question 2. I put this question in the back of comments from Nature Scott on the first draft agenda. And it was just a wee discussion around what test you think I should apply when assessing whether or not the significant effects on the wildland qualities are acceptable. And going on from that, is a test of whether the integrity of the wildland could be compromised relevant as part of that assessment. I'm going to start with this one with Nature Scott because it came out with some of your comments on the agenda, as I said. So maybe you could comment on that first, and then I'll go across to the appellant for their comments.
Thank you. Nature Scott have not applied a test of whether the integrity of the wildland area could be compromised. This is not a consideration with Scottish planning policy or NatureScot's 2020 wildland guidance. Our 2020 guidance, which is CD 519, sets out the steps to determine the effects on wildland qualities and when they're significant. So we use the test of significance, which if you want to go to CD 519, is para 29, which is all the pages I'll refer to will be electronic pages, just in case you've got hard copies as well, which is page 7 of the guidance. And this sets out, I'll just let you get there, this sets out where there is a material change in experience of any quality. So that's just where it sets out about the test of significance. And we've set this out within our advice and indeed our hearing statement, which both follow the 2020 guidance. So in taking this view, we have considered the contribution of any area affected to the wildland area, and para 33 of the guidance, which is on page 8, is that reference. So as an example, if the areas affected made little contribution, for example, to the wildland area, maybe due to qualities being poorly expressed, it might be that further attrition may not result in an overall significant effect. However, in this instance, the areas that are affected span across the interior, which exhibit high degrees of wildness, and therefore we consider they make an important contribution to the whole of the wildland area. So significant effects in the interior would affect the whole. And in concluding on the effects of Drumhollistan 2, we state in our hearing statement, which is CD 10.2 at paragraph 8.3, that the wildland area would be compromised. So I wonder if I can take you to CD 7.2, which is the previous reporter's report for Drumhollistan. And it's electronic page 74, which is para 4.122. It's a big document, so I'll just let you get there. Okay, so they state there, we consider that a key aspect of our consideration of the overall effect of Drumhollistan upon Wildland Area 39 as a whole is whether the wildland area will still be capable of providing an experience of wildness of a comparable strength to that currently. We think this is a really useful statement and fits well with our own definition of integrity, which can be found in our landscape policy framework, which is CD 512, electronic page 15, that's para A12. And this is where we describe the term integrity, albeit in relation to designated landscapes. And as we all know, wildland areas are not designated. So I'll just read that paragraph for those who don't have documents available. Overall integrity means the wholeness of the area, the unity or soundness of the whole being unimpaired, recognising that the entire area of the designation is valued and adverse effects to part of part of it is damage to the unity or soundness of the whole. So those things tie up quite nicely. So just to continue your question, NatureScot have a further internal process of determining potential national interest and deciding whether or not to object. So putting it another way, are the effects significant enough to merit a NatureScot injection? It's not the case that whenever significant effects on wildland qualities are identified by NatureScot, we object, because that's not the case. Acceptability is an overall judgment in terms of applying, we believe, a planning balance, and is not generally a term that NatureScot would use in this context, as we provide advice on just one aspect for your consideration. However, it may be that significant effects don't meet our threshold of national interest. So the significant effects on wildland may therefore be deemed acceptable in those terms. And this is supported by our landscape policy framework once again. So that's back to CD 512. Just above that, so it's A10, which is page 15. which I'm just going to read you as well. So, in considering the acceptability of the effect of policies and actions on the landscape, SNH's landscape advice will be set alongside the full range of natural heritage considerations and have regard to its balancing duty as required by statute. So whilst that document is dated, it's still relevant, we feel. Thank you.
Okay, the appellant, do you want to come back on those points?
Yes, absolutely. So on the first part of the question on acceptability, I think we're agreed, and I think Ms. Harry made the same point, that there isn't a specific policy test for acceptability of projects outside of wild land areas beyond the planning balance and the reporter's judgment on the planning balance. And this was the approach the previous reporters took as well. On the second part of the question, integrity, the appellant's position is that we don't consider reaching an overall conclusion on integrity is essential, or that it triggers a planning decision one way or the other. We just think it's helpful to bring the strands of the individual significant effects together in an overall conclusion. I mean, especially given that the eventual decision the reporter needs to take is a binary one. So the appellant's position is that drawing a conclusion on integrity is useful and relevant, but not essential. Having said that, though, and just having listened to Ms. Harry and also having read the Nature Scott submissions, I do wonder if there's actually that much between us here, and it might be a little bit of the only word in my head is semantics. That maybe belittles it, but on terminology, because the Nature Scott hearing statement concludes, and I had marked exactly the same paragraph 8.3, that the proposal would seriously compromise the value of the wildland area, which reads to me like drawing an overall conclusion based on the individual significant effects, which I think is what the previous reporters were striving to do in their conclusion on integrity. It's what the appellant has done in our conclusion on integrity. And clearly, as we flagged the agenda item 1, there probably is a difference of opinion on that importance, with Nature Scott explaining there that they were of a view that overall significance was sufficient to trigger an objection, whereas the appellant, perhaps unsurprisingly, sides with the previous reporters that although the significant effects are recognised, they're not in themselves sufficient to warrant a refusal.
I probably agree that there isn't that much between you from what I'm hearing and what I've read. I think it's helpful that you're both agreeing there's not a specific policy test. I think that's helpful, and there's not a test based around the word integrity, so to speak. So I think that's really helpful from my perspective. And I think you've both drawn a conclusion using your own terms to explain that conclusion, albeit those conclusions are different. But I think I would probably agree with the fact that there's actually not much difference other than the conclusion you've reached, obviously, as to the importance of the significant effects. Is there anything, Ms. Harry, you want to add? Because if not, I'm quite happy to move on to the next question, because I think I'm happy that I understand the party positions and what the difference is. I think you're shaking your head, so I think... And
nothing to add.
Ms. Hutchinson, are you happy again to move on to the next question?
Yes, happy.
Okay, so we'll move on to question 3. Now, this was a question I asked at the hearing session on landscape and visual impacts. I've put it on this agenda because I know Nature Scott weren't there, although Mr. Finlay was there on behalf of the council. And it really is about what I should take from the previous reporters' conclusions and findings, and whether this scheme needs to consider its own merits rather than major in comparison against the previous scheme. And I think last time we came to the point that what the appellant's done is they've benchmarked the scheme and how they've designed the scheme, comparing it to the previous scheme to try and mitigate the concerns that the reporters had in the previous scheme, which led to the refusal. So obviously, there's a basis of I need to make consistent decision making in planning terms, that I need to be consistent with previous I suppose conclusions reached by the reporters, but it is for me to look at the scheme afresh and determine whether it is acceptable and meets the policy tests. Is that a fair summing up of the previous hearing session? And again, is there anything parties want to add? I'll start with the appellant on this one first, and then it's maybe one for you, Mr. Finlay, but I'll go to Ms. Harry first and see if she wants to add anything. So for the appellant, Ms. Hutchinson, is this one for you to comment on?
Yeah, really good. I think you've nailed it there. That is, I think, a very accurate summary of where certainly we landed after the last hearing session. I mean, the only thing I would perhaps add is that yes, consistency in decision making is a material consideration, and I think what flows from that is if departing from a previous decision, there needs to be just a reasoning or justification for that.
Yeah, I'd agree with that too. Ms. Harry or Mr. Finlay?
No, I'm happy to come in on this. Whilst yes, I would agree with what you've said there. I think we'd probably like to add something into the second kind of part of your question, which is the which aspects of the report are important, and what should we draw your attention to, and whilst the landscape and visual effects of the previous proposal were the primary reason for the refusal, the impacts on wildland were of a severity that augmented that reason. So the findings of the previous reporter we consider most relevant kind of fall into three categories, we felt. So the weight to be given to the 2017 guidance is one, the significant effects identified for what are now sub-areas 1 and 3, and the cumulative effects with Limekiln 2. So if I could just take you through those three sort of categories. So it'd be helpful to have the CD1 7.2 handy, which is the reporter's report. So with regard to the weight for different guidances available at the time, we think it's important to note the emphasis that the previous reporter gave to the 2017 guidance. So at para 487, which is page 68, the reporters say, given there are inherent uncertainties over what final form of draft guidance may take, the weight we attribute is reduced. For this reason, we conclude that no greater reliance should be placed on the 2007 guidance. Sorry, that greater weight should be placed on the 2007 guidance. Noting, again in 4.89, that they state, we have used this range of evidence to draw our own conclusions on the effect of Drumhollistan on Wildland Area 39. And go on in 4.90 to say, having regard to the 2007 guidance, and also to a lesser extent the draft 2017 guidance, we find no clear established or potentially emerging test or threshold. Our conclusions below, therefore, reflect our own professional judgment, borne out of the submitted evidence and our own experiences. So the previous reporters did not have that benefit of finalised guidance, which of course you have. And therefore you may present your own professional judgment informed by the updated and more certain evidence before you. So the second point is with regards to the significant effects identified for what are now sub-areas 1 and 3. So just to remind ourselves, sub-areas 1 is generally to the west of the Ben Ratha Ridge and north of viewpoint B, and sub-area 3 is the smaller area in the heart of the wildland area around viewpoint, just east of viewpoint 3. So it's important to remind ourselves that the previous reporter did find significant effects within sub-areas 1 and 3 in the north and east of the interior of wildland area 39, and concluded at 4.116 Hollistan would significantly detract from the qualities of Wildland Area 39, interrupting the simplicity of the landscape and its strong horizontal emphasis. Its presence would affect the sense of solitude, which is provided by the 360-degree experience of the area. So with regard to the northwest sub-area, which is now sub-area 1, and they changed name, the reporters identified in para 4.95, which is page 69, and 4.97, the nature of the topography is such that central parts of the sub-area are well contained, with few or no external influences affecting the strength of wildness. Our findings are consistent with those of SNH in this regard. And then they go on in 4.109, an area where the wildland qualities and attributes are strongly expressed with little in the way of influence from development or land use out with the wildland area. So concluding, if we go back to 4.100, they say we consider significant effects would arise deeper into this sub-area. So that's a sort of an area I'd like to draw your attention to, is that they did identify significant effects on the first proposal within those areas. And then a shorter point finally, with which we'll come on to again later, I think, is the cumulative effects with Limekiln 2. So with regards to the cumulative effects, the reporters were very clear in 4.129. I've omitted to put a page reference. My apologies there to that one. We conclude the cumulative effects of Hollistan in addition to Limekiln 2 would be significant and adverse. So that's just the 3 points I'd like to make here.
Thank you, and it's fine having paragraph reference, so don't worry about the page. Pages are helpful, but the paragraphs are even more helpful. Pelin, do you want to comment on that? Any of that? The points that Nature Scott have drawn to my attention?
Yes, absolutely. I'll perhaps let Ms. Rylett respond on the detailed points, but if we've got anything we feel we want to say on that. But before I turn to that, just taking a slightly higher level view, we've obviously on this agenda item sort of summarised the discussion in September on the relevance and importance of the previous decision, which I think we're agreed and aligned on that. So just applying that to the wildland impact as we find them for DH2 before us. Clearly, Ms. Harry's identified some specific points of difference, but I think overall the approach is, to my reading, very similar to last time. You know, the overall conclusions of previous inquiry statements and this hearing statement are, you know, almost word for word the same. And there's various statements in the Nature Scott hearing statement. For example, paragraph 3.1, that our view has not changed, and at 6.19, explaining that the effects on wildland are largely similar. So at an overall level, it feels as if not much has changed in terms of the advice you're receiving, ma'am, from Nature Scott. Both parties agree that the effects with the revised baseline are less than those of DH1, albeit they are significant. And I think the term Nature Scott used is a slightly lesser degree. Again, paragraph 6.19. So the previous reporters concluded, as we've heard, that the impacts on wildland area 39 were not in themselves a reason for refusal. So the applicant's position is quite simple, that not much has changed in terms of the advice you have. The impacts are in fact reduced, and so there's a reasonable expectation that the reporter will take a consistent view or a consistent approach to wildland impacts as the previous reporters did. Ms Rowlett has anything specific on.
I would like to just add a point of clarification on the previous reporters. Paragraph 4.87, where they say, given the uncertainties over whether the current form of guidance, which was then the draft 2017, may take weight, the weight attributed is reduced because it's in draft form, and they put greater reliance on the 2007 guidance. I see that really as an observation about the relative weight between the guidance, and it's worth remembering that for Hollistan 1, we undertook on behalf of the appellants an assessment using the 2007 guidance and an assessment undertaken using the draft 2017 guidance, and then we were then directed at the pre-planning consultation by Nature Scott to complete the assessment using the 2017 guidance for Drumhalliston 2. And that was agreed in the Statement of Agreed Matters. And then in paragraph 4.89, the reporter refers to the range of evidence that they have before them, including bespoke approaches such as that presented by Dr. Carver, and they then confirm that they've used this range of evidence to draw their own professional conclusions. And on the point about own professional judgment, that is what any landscape architect would be doing in any event.
Okay, thank you for that. Ms Hyde, do you want to respond to those points? Anything further you want to add?
No, there's nothing I want to add here.
Could I perhaps just butt in to add something there? Whilst it's been suggested that not much has changed, there was a significant dispute at the first inquiry as to which guidance should be followed, with the applicants, I think, all placing much more reliance on the 2007 guidance as updated in 2014, whilst SNH, as it then was contesting for application of the draft 2017 guidance, which is much closer to the current 2020 guidance. And whilst I know one can see what the report has said about it, but overall, I think it's a reasonable conclusion that they place greater weight on the older guidance, not the draft 2017 guidance. And that is, in our view, a material change between now and then. And indeed, whilst they've drawn their own conclusions, as Ms Rowlett said, by reference to paragraph 489, I think the framework within which they did draw those conclusions has changed. So I think akin to our Highland Council's approach, whilst we agree that as to the approach to the previous reporter's report, we consider that the appellants are underplaying the amount that has changed, both for that reason and for the reasons that Ms Harry has already given.
Sorry.
Just tell on that point, can I just ask whether you accept that the framework has changed? You're basically on different guidance. And I guess any other comments, because Ms Riley, you did want to comment on that. So if you can answer that question and make any other comments you want to make in response.
So the response that I wanted to make to Mr Finley's comment was that in paragraph 4.86, I think my recollection of Drumhallistan 1 and the reporters are the same here, we note that the applicant has adopted a somewhat more relaxed approach than SNH or indeed the Limekiln 2 applicant over the question of to which assessment methodology ought to be followed. We didn't particularly mind, and having looked at all three methodologies together, I don't see that there is a great deal of difference between the draft 2017 guidance. It follows the same 5 basic steps. It directs reference to GLVA 3 approach, and there's not a huge amount of difference between that and the guidance in 2020. And it's also agreed in the statement of agreed matters that there's not a great deal of difference between the assessments because of that. And I think if you could just remind me what your supplementary point was, please, Ma'am. Question.
I was just going to ask if you accepted the framework has changed. I think you probably do accept the framework has changed, but the degree of change is, there's not a great degree of change.
Yes, between 20...
There's not a material difference between them.
Yes, that's correct.
Ms. Harry, can I ask you to respond to that?
Yes, I think just for clarity, we've got 3 bits of guidance we're talking about here. So the 2004 approach, the original one, which is what the original reporters placed their greater weight on.
Sorry, that was 2007.
Sorry. Yes, the original one. Yes. That's right. That one, there is a material difference between that one and either 2000 or 2020. I think I'm in agreement with Ms. Rylott that the methodology for the draft, which was 2017, and what is now published as the 2020, the methodology for those is very similar, but the big difference is between the older version, and I think that's where we want to draw attention to say, but that's where the reporters focused, they put their reliance on it. Excuse me.
So their reliance was on the 2017 guidance, and your evidence is that there's a material change between that and the guidance that's now in place, 2020 guidance, which is what you've used to base your assessment on in your hearing statement. Is that the difference?
The reliance was on the 2007 guidance, not 17.
Sorry, I meant 2007. Yeah, sorry, get muddled up with our numbers here. So again, reliance on the 2007. Your assessment in your hearing statement is 2020 guidance, and there's a material difference between the 2007 and the 2020 guidance, which therefore leads to different conclusions and different significance. Okay, Ms. Rylott, do you want to come back on that?
I still think that when you look at the assessment conclusions the previous reporters have gone through in terms of the various sub-areas that they've looked at, the detail in terms of the sensitivity of the perceptual responses to the wildland, and also they've had reference to the wildland qualities and the magnitude of change they've applied, and their overall conclusions on the effect is still broadly similar to an assessment that we see before us from Nature Scott or myself on the same wildland.
If I might just make one supplementary point as well, that the previous reporters did have before them advice on the basis of the 2017 and 27 guidance. So the 2017 guidance is not a new difference for this scheme in terms of the assessment. That advice was available from Nature Scott to the previous reporters.
Okay, Ms. Harry?
Yes, I would agree that evidence was before the reporters, but I think it just goes back to the point I'm making is about the reliance the reporters place on that guidance. So just to repeat that point.
Perhaps I could add that our point is not that their findings aren't relevant. It's just that the relevance has to be placed in proper context.
Okay, I think that's been a really helpful discussion. I'm happy again that I understand the parties' views on that. Obviously, I've got all the documents in front of me anyway. Any final comments on that question before I move on to question 4? No, okay, lots of speaking heads. Let's move on to question 4 then. And this is about the assessment that the appellant carried out and Nature Scott carried out in its hearing statement. Now, I noted that the appellant assessed 4 sub-areas, and we've kind of touched on those already this morning, whereas Nature Scott focuses on the whole of the wildland area and the wider landscape context. And I wondered whether this has an impact or effect on the conclusions both parties reached, and whether one understates and one overstates the effects. I'll start with the appellant on this one first, and then I'll come to Nature Scott.
So the previous report has set out the study areas because of the variability present in the wildland qualities in terms of their sensitivity, and also the variability of the magnitude. When you look at the ZTV, you can see there's variability in visibility across the wildland. And they considered it more appropriate to use sub-areas in order to fully understand the extent and the level of effect. And you can see that in their report, paragraph 4.19, where they say, based on the zones of theoretical visibility, it is evident that the extent to which the visibility of the drum Hollistan would occur is geographically variable across wildland area 39. The precise characteristics of the wildland area 39 are also similarly variable, and for this reason, before considering the effect on wildland area 39 as a whole, we consider it appropriate to first base our assessment on considering the wildland effects on notional sub-areas, a term also used by the Limekiln 2 application, which we have adopted in our own assessment of that proposal. And then they go on to say that both, or I would go on to say rather, that both the 2017 and the 2020 wildland area guidance advise on the selection of study areas or a study area, which may be different from the wildland area as a whole, encompassing areas of the wildland area likely to be significantly affected, and also taking account of the cumulative effects. The sub-areas used by the previous reporters were adopted by me, although the names of them were slightly changed. Now, whilst it might be easier to assess the whole wildland in one go, our assessment of the various sub-areas in the wildland area provides, I would suggest, a more detailed and granular assessment, which one would expect in an environmental statement setup. It rightly recognises the variations between the baseline sensitivity of the wildland qualities, as well as the variability in the magnitude and the level of effect across the wildland area sub-areas. The previous reporters noted considerable variability and undertaking their assessment due to undulating land, distance from the proposed turbines from the boundary, visibility extent, direction of view, so on. And we touch on this in our rebuttal, CD 11.2, page 3. And we've commented on what we have described as Nature Scotland's generalised assessment of the significant effects across the northern part of the wildland area within 8 to 10 kilometres. and that doesn't appear consistent with examples of other wind farm assessment in this area. The applicant's more detailed cumulative assessment, which accounts for variation of sensitivity and magnitude, consequently finds variation in the level of effect of different sub-areas. For example, the level of effect in the northwest sub-area ranges, we say, from minor to moderate, which aligns with the previous reporter's judgment that as you move from the edge of that wildland and you go deeper into it, then the sensitivity increases. And therefore the level of effect is variable across that sub-area. We found moderate to major moderate effects on sub-area 2, and thus the applicant finds that the geographical extent of significant effects is not as widespread as implied by Nature Scott.
So your view would be that Nature Scott have over-assessed or the significance by looking at the wider area as opposed to looking at the sub-areas to understand where the greatest significance is and how that relates to the wider area?
I think there is a danger with taking just one assessment of it as a whole. You come to the conclusions, and there could be the implication in reading it that what they mean is the whole thing is affected to the same degree, or that the extent of significance or the significant effects is more widespread than when you look at it in detail and break it down and discover that the effects where they are going to be significant are more limited. Nonetheless, they are significant.
If I might complete this with a question, which I think we understand, but I think Ms. Harry made the point earlier that the Nature Scott approach is that if there's an effect on a part, there's an effect on the whole in terms of reaching conclusions on significance for the whole area for each quality.
I didn't think she said that, but I'll ask Ms. Harry to come in and respond to the points made and also answer that question so we can clarify that.
Yeah, that's not what I said, and that's not the case. Shall I respond to your question just now? Yes. So we don't consider, this is in response to question 4, we don't consider the approach in study areas taken by the two parties makes any material difference in the conclusions reached. We also don't take issue with any of the sub-areas identified by the applicant because these broadly align, as Ms. Rylett said, with the previous reporter's consideration, albeit that they're differently named, which is fine. We think it's useful to describe where effects occur. There is a risk, however, sometimes by subdividing a relatively small wildland area, which this one is, that effects can be diluted by the consideration of diluted in the consideration of the wildland area as a whole. And sometimes we have seen lots of assessments where this is the case, and effects have been described as localized, and therefore, a lesser weight has been given to them. So our experience is that from a number of assessments we've seen, it can be sometimes unhelpful in the wider consideration for a decision maker to understand those wider effects on the whole. However, in this instance, we don't consider the effects have been understated in the assessment because, in our view, they do reflect the outcome of the previous application, and they have been correctly identified as significant for wildland qualities 1, 2, and 4 in sub-areas 1, 2, and 3. So our difference, going back to the first question, really is in that next stage of judgment, that being that whether these significant effects are indeed significant enough. For us, it's meeting that bar of national interest, and of course, for others, it's meeting the planning balance.
Okay, so thanks for clarifying the question, Mr. Hutchison. So effectively from that, you think there's no material difference. I think importantly from my perspective, you don't think the appellant understated it and by splitting it out into sub-areas.
No, I mean, it's an approach that, I mean, this is still an evolving approach with wildland areas. We know that, and there'll be different instances for different cases. And the important thing is that the effects, when they're identified, are brought together and looked at the whole. And I think Ms. Rylett's already mentioned that you know, that's the key to this. And I think just a general kind of word of caution, I guess, that we're giving, not just here in this case, but all instances where effects on wildland is about not subdividing for the sake of subdividing, and not subdividing with not an intent, but what could be considered as identifying localized significant effects in a very small area, which would then be diluted when looking at the whole.
But here, I think Ms. Rylett's explained, I guess based on the previous reporter's approach, how the areas came about, the subdivision came about, which seems to be sensible as opposed to being intent-based. It seems to be there's a logic behind it, how the areas have been subdivided. So I'm taking your evidence that that is an acceptable approach. It's not understated. It correctly identifies which qualities are impacted and the significance of those effects. And really, it's the next stage as to whether that's acceptable or not that is where the difference between the parties is. Is that fair?
That's fair.
Okay. Ms. Rylett, do you want to come back and respond to any of that? Again, I think there's probably not much difference between you. I think it's reassuring that H. Scott have said that they don't think your assessment understates the effects. And again, I think it comes down to that point as to whether the significant impact is acceptable or not. I think that's where the crux of it is. So is there anything you want to come back on?
No, I think we're content with that.
Okay, that again is helpful. If we move on then to question 5. And this was just picking up something in the appellant's rebuttal statement, paragraph 1.2. And that's the point they were saying that despite the fact there's considerable litigation embedded in the scheme, Nature Scott does not appear to have recalibrated its position and adopts much of the assessment undertaken for Drumhollistan 1. And I just really wanted Nature Scott to comment on that, whether you think that's a correct statement, that's a fair statement. If you haven't done that, should you have done it? So really just get your views around that in response.
Yeah, to be clear, Nature Scott have undertaken a new assessment of Drumhollistan 2, and we've not simply adopted the previous assessment. And there's really two issues here: the effects that Nature Scott identifies and our position. So address firstly how we have calibrated, how it's referred to here in terms of our position really. We have considered the previous reporter's findings very, very carefully, and do respect the overall planning balance that has been needed to be applied there. So advice in this case is limited to the effects on wildland, which is simply one part of that wider consideration. And we do maintain that advice and don't consider it's at odds with the previous reporters and how they've ultimately expressed their views. Secondly, we recognise that efforts have been made to mitigate some of the adverse effects identified as a result of that first proposal. We focused our advice on how the new proposal might affect the wildland qualities, and we don't consider that the reduced scheme will result in a markedly reduced effect on how the wildland qualities are experienced. Sorry, did I say won't? I think I meant will. Let me just read that sentence again, because that's quite important. So we considered that the reduced scheme will result in a markedly reduced effect on how the wildland qualities are experienced. So that's just important, sorry. And I think it might be helpful, sorry. There's a lot of double negatives there, isn't there? We don't think that the reduced scheme...
Put it in a positive way.
Put it in a positive way, thank you.
So perhaps I can ask the question, do you think that the reduced scheme result in a markedly reduced effect?
No, that's
what I thought your evidence was. But I just wanted to
it was a poorly worded sentence, it's my fault.
No, it's too much time spent with lawyers probably, you're getting into double negatives.
And I wonder if we could use a couple of visuals here. It's probably high time we looked at some viewpoints anyway, isn't it? I put, hopefully these aren't going to be too laborious for you to find. So I thought it might be helpful to look at Shannon which is viewpoint A, and compare Drumholston 1 and Drumholston 2. So I'll just read out the references for those who don't have it available. So CD 3.2, volume 3. And it's the visualizations folder. And within that, it's the wildland visualizations. And within that, it's figure 7.49 we want to open. So that should be Shannon. That's for Drumholston 1. And at the same time, if we could have Drumholston 2, which is CD 1.6, figure 7.54 available. So you've got both. I'm just waiting for you to. You've got those.
I have got both the ones on my floor, so I might dip out the pictures.
That's fine. I know. I was wondering whether you would have them in paper or not. But essentially, if you go to the last page of each of those, so it's page 7 on Drumholston 2 and page 6 on Drumholston 1. So that should be the same view, but with different. This is where actually on screen, you know, it's almost easier because you can flick between the two. Okay,
right.
can you see both of those in front of you?
Okay.
So using that location of Shannon across, generally looking across sub-area 1 here, so that's the area we've been talking about, which is the north west of the wildland area, to compare the two proposals. We note that the proposals may differ. There's definitely left turbines we can see, although they are taller, but the turbines continue, in our view, to form a dominant feature, detracting from the wider panorama available. So this is all to do with our calibration, our understanding of, we haven't just looked at the difference, we're looking at what does the new proposal do when we're looking at the effects. And then if we can do the same thing at a different viewpoint, just for balance. So for Lochanoon, which is viewpoint B, so if we could have for Drumholston 1, CD 3.2 again, volume 3, in fact, you're in the same folder, but this time it's figure 7.50. And again, scroll down or flick over to the last page, which is the visualization, page 6.
Yeah.
And then in the same document for Drumholston 2, it's figure 7.55.
Yep.
So here we're looking across sub-area 3, which is that smaller interior sub-area. Sorry, no, we're at viewpoint B, aren't we? So we're in viewpoint sub-area 3, not looking across it, looking to the north. There's a notable change here in the proposal, with fewer turbines, far less stacking. But the important issue here is the effects on the sense of expansiveness and the diminishment of the subtle knolly ridges and hills. And this is all described in our hearing statement at para 620, remains. The effects of the proposal on wildland qualities 1 and 2 in particular remain, in our view, significant, demonstrated by these 2 example viewpoints. So just to conclude with that question, yes, we have considered this as a new application. We haven't simply done a kind of comparison of compare and contrast, and taken our view. So we have we don't consider that. Sorry, we have recalibrated. We have considered this carefully.
Ms. Rylott.
Yes, so looking at viewpoint A, I think it's worth noting that the difference between those, although the 2 schemes affect the same extent on the horizon or similar extent on the horizon, there is a notable difference in the numbers of the turbines and the density of the scheme, and therefore the scheme appears lighter. It's still an impact, and I think, you know, it's worth looking at the fence line in the foreground and seeing, you know, the relative scale of that in comparison to the turbines in the background, and what's drawing your eye to them. And then also when we look at viewpoint B, Loch Nanoon, we actually see that there is probably a more significant reduction in the horizontal extent of the view that's affected by the turbines. It's actually set out in table 5.1 of my hearing statement on page 47, that the reduction in the field of view goes from 12 degrees to 8 degrees. And we move from a position of seeing 17 turbines to a position of seeing only 7 turbines. And I think you can go through all of the viewpoints and do this comparative exercise, that there is a reduction in the sort of volume, if you like, in terms of the turbines and their densities that's apparent in those views. But we accept that the wind farm is essentially still visible from those viewpoints.
I think perhaps if I could just follow up with one, I think, clarification on the rebuttal and that paragraph. I think what it talks about is the recalibration of the approach that Nature Scott took, which is primarily a position that, having objected last time and the reporters having found not a reason in isolation and wildland for a refusal, the appellant's position is that Nature Scott may have felt it reasonable not to object this time. That's the key point. It's again coming to acceptability, and that's the key sort of recalibration that the appellant would have considered could have been reasonable in the circumstances. Although the nature of the advice itself before you, it clearly has been reviewed, and the conclusion reached that its TH2 has a effect to a slightly lesser degree. So the recalibration is less on the assessment and more on the overall conclusion drawn, is the point in the rebuttal. If that's not entirely clear, then hopefully this has been an opportunity to clarify that.
But no, it is helpful. But I guess it would still be open to Nature Scott to reach a conclusion that there were significant impacts or significant effects, even though the scheme was reduced, if they're looking at it fresh. Of course. Yeah. Okay. Ms. Harry, do you want to?
Could I just preempt Ms. Harry before, because it seems to me Mr. Hutchison's point displays, if I can say so, a misunderstanding of Nature Scott's role that Ms. Harry tried to allude to in the answer to the second question. Whilst the Nature Scott's decision is whether to object or not, and that's whether it considers the impacts as such as to raise the issues of national importance, it doesn't take a view as to the overall planning balance. So to suggest that Nature Scott should revisit their decision to object simply because in the overall planning balance the reporters did not consider that the wildland was by itself a standalone reason for refusal, misunderstands the role of Nature Scott. Nature Scott's, arguably, the reporters endorsed Nature Scott's concerns about wildland, didn't suggest that they were improperly taken or their objection wasn't proper. But Nature Scott do not carry out the balancing exercise that led the reporters to the view that the wildland didn't of itself justify a reason for refusal. That's an overall balancing exercise as to acceptability or otherwise, which Ms. Harry made clear in answer to question 2, Nature Scott don't carry out. So whilst there may be some cases where recalibration may mean subsequently Nature Scott might not object, in our submission that's a long way from this case. So in terms of the, if that was the point that the appellants were taking, in our view, it's a misguided one on and misunderstands the role of Nature Scott. The important point, and I'm sure Ms. Harry will come back to respond to Ms. Rylett now, is that Nature Scott recalibrated or considered carefully, because recalibration can mean different things to different people, considered carefully what the reporters had to say, as indeed did Ms. Rylett. And there was a far greater degree of difference between the reporter's view and Ms. Rylett's on one hand, and the reporter's view and Nature Scott's on the other, and have given their evidence on Drum Hollistan too. So hopefully that makes Nature Scott's position clear. Ms. Harry can tell me if I've got that wrong, and otherwise respond to Ms. Rylett.
No, that's absolutely clear. And if you've got no questions on that part, I just wanted to respond to Ms. Rylett's point about taking you to the two viewpoints again. So it's slightly stepping back. Just the point I think I was making, and the reason I took you to those viewpoints was not about. It was to confirm that yes, there is a difference in these two proposals. They are different proposals, but the question that we're asking is, what are the effects on the qualities of wildland? Not about visual effects or necessarily how many turbines are visible. It's about how this affects those qualities as they've been described, and that's the key point. So whilst yes, we do recognise this is a smaller scheme, it doesn't necessarily mean that those effects will be reduced.
Ms. Hutchinson or Ms. Rylett, do you want to come back and comment?
Yes, I mean, I think Nature Scott do accept in their, I think it's in their rebuttal that they in their hearing statement that there is a slight reduction in the effects, and they do recognise that.
And finished. Just responding to Mr. Finlay, the appellant does understand the approach that Nature Scott has taken. It's given its advice on the first scheme, first iteration DH1 as it saw it. It's given its advice on DH2 as it saw it, and it's not pulled any punches on the basis of the previous reporter's findings of the planning balance. We understand that. And we understand that role. It was just, I think Mr. Finlay did mention that there are occasions where Nature Scott will, having been through one inquiry, decide not to object to another iteration of the scheme in light of clear findings. And we thought this could be one of those occasions, but we respect that Nature Scott has chosen to offer the equivalent advice, and it doesn't make any particular difference to our case, which is the same.
Okay, I mean, I think I did note that Nature Scott did accept a slight reduction in effects. Obviously, not enough in its view for this not to be a scheme it would object to. So I understand what Nature Scott have done. I understand the difference of views. Going to the viewpoints was helpful, but I think we can move on to question 6. Let's kind of go back to the guidance, and maybe it's about the responses makes no material difference. I just noted that in terms of the 2017 guidance, step 3, it's a sensitivity of the study that's assessed, whereas in the 2020 guidance, it's the sensitivity of the wildland area quality, so slight nuance there, different emphasis. And I just wonder if that made any difference. I'll ask Nature Scott first.
Yes, so a continuation of how we've been discussing this. We do accept that at the time of the application, the agreed approach was to use the 2017 guidance, because at the time that was the most up-to-date guidance. But we're now in an appeal process, and we do, of course, have the published 2020 approach. which was used for all parties at the Glen Sherrow PLI in September of last year and was accepted by that reporter. So we feel that this is the most important guidance and relevant at this stage. Our and others' experience of using the 2017 guidance, because it was in draft, noted that in trying to identify the sensitivity of the study area as a whole, which often could be an entire wildland area, it did become generic and less helpful than it might be. It didn't really allow for how each quality might have the ability to accommodate some forms of change, whilst others would be inherently more susceptible. So, for example, the sensitivity of wildland quality 1 to the proposal is considered here to be high, whereas wildland quality 3 is low, and that we're in agreement. So this part of the 2020 approach has been adopted by the applicant in their wildland assessment, as each subject area has been assessed by individual wildland qualities. Ultimately, though, the 2020 guidance allows for a more nuanced approach, as it draws out which wildland qualities are more sensitive than others. And it does this by setting out factors for the consideration of sensitivity, which are in paragraph 23 of the guidance, that's CD 519. So just to be clear, we don't think that the different approaches adopted make a difference to the conclusions reached by both parties.
Perhaps I could just take that one stage further. It doesn't take the 2020 guidance is more helpful, and if there'd been strict following of the 2017 guidance, it might have made a difference. But because Ms. Rylett, as Ms. Harries pointed out, did assess each sub-area by reference to each individual wildland quality, then there is in fact no real difference in this case, as I understand it. So just to be absolutely clear, we think the 2020 guidance is better, but actually the way both parties have gone around it has led to a directly comparable approach, and there's no distinction to be drawn.
Ms. Violet, did you generally agree with that? Oh, you're mute at the moment.
Sorry, yes, I said I'm largely in agreement with the first part of the response from Ms. Harry and Mr. Finlay. We did note in looking at the 2017 guidance that there is small print in step 3 that does refer to the sensitivity of the wildland quality, its attributes and perceptual responses to the proposed development, and that is one of the reasons why we have taken that approach. In terms of trying to make the two assessments directly comparable, there are other issues, and I've actually tried to draw a table up that compares the two assessments, and it is very difficult because there are other differences which we may come on to later between the two assessments. The first of those differences is the use of terminology, and we have, because the guidance directs us to take a GLVIA approach, we have used the terminology used in our LVIA assessment. So when we're referring to sensitivity, we're talking about low, medium, high. And we've also taken that same terminology when we're talking about magnitude and also the level of effect. And then when we go across and read Nature Scott's assessment, we have a little bit of difficulty in understanding some of the terminology that has been used because some of it is not directly comparable. For example, they use the term major or substantial, or they may refer to something as very high sensitivity, which is off the top of our scale, if you like. So with that allowance, we would say that there is a problem in comparing the two assessments.
And actually, that probably takes us into the next question, which we can do at this point too, which was where I did ask Nature Scott to explain the terminology they have used, because I noted that was the word differences. So maybe how you could morph into that question and come back to anything else you wanted to discuss in question 6 too, just maybe go on to that point about explaining the terminology you've used in your hearing statement.
Yes, that's absolutely fine. Sensitivity as per GLVIA, which is CD 5.1 para 5.39, is a combination of value and susceptibility. So this is where we've got the important division, I guess, which is useful. So it's Scottish Government's view, which we agree with, that wildland areas are high value, national importance. Therefore, the variable here is the susceptibility when considering effects on wildland. So importantly, it's susceptibility of a particular quality of the proposal that should be assessed, not generic susceptibility of any kind. We've identified a general reduction in susceptibility of wildland qualities as a direct result of the change in the baseline, that being the consent of Limekiln 2. So just I think the importance here really is about understanding how we've used the term, or how the terms sensitivity and susceptibility have been used throughout the different guidance. And we think it's more helpful here to use the correct term really is susceptibility, because that's the variability, but actually it's the combination of that plus its value that draws that conclusion. I think you wanted me to address 2 points, and I've actually forgotten what the second point is. Sorry, was it question 7 and something else?
Any response you had to Ms. Rylett's point, which was really saying that they took the approach of looking at the wildland qualities, but it's not directly comparable to the two assessments because there's difference in terminology, which you've now come on to. So is there anything else you want to say in relation to terminology, or I'll go back to Ms. Rylott?
No, I don't think so. I mean, I accept there are some differences in the terminology used. I think probably in what we're looking at here, that's probably, it might be some slightly difficult, but I don't think that should be a major obstruction in understanding the effects, given that we've got agreement on that.
And the reason is just in clear in my head, this general reduction in susceptibility is because that baseline's changed. So your factor in Limekiln 2, that's changed the baseline, therefore susceptibility, it's gone down.
Yes, so Limekiln 2, when built, will have the effect of substantially diminishing the sense of awe and perceived naturalness, which are underpinning wildland quality 1, and the sense of remoteness, solitude and sanctuary, which underpin wildland quality 2, across the north and east of Benrath Ridge line, which is that, go back to sub-area 2, and a bit of sub-area 1, and in more limited areas to that interior. So the effects now reduce the overall susceptibility of these two qualities where they're best expressed, which is in those areas, to further change of this type. So it's important that it's further change in relation to wind turbines. So the applicant's wildland assessment concurs with this, specifically for sub-area 2, and that's para 1.5.4.2 in the second bullet. This is also supported by the previous reporter. So we're going back to 7.2, which is the report, para 4.128 and 4.129. And I'll just read that. The addition of Limekiln 2 to the cumulative scenario would result in Drumhollistan 1 that being, having a more markedly combined cumulative effect upon wildland area 39. And then goes on to say, we consider the magnitude of effect that would be increased markedly in the presence of Limekiln 2. And then go on to say, we find the effects of both developments to be broadly comparable, particularly because of their individual and cumulative effect upon sub-area 2, which is, is sub-area 2. We conclude the cumulative effect of Drumhollistan in addition to Limekiln 2 would be significant and adverse. So I'm just drawing you to that because it's confirmation that there would be a change in that baseline, and it's about be susceptibility of qualities as a result of Limekiln 2, which is now part of the new baseline.
Thank you. That was useful. Ms. Rowlett, do you want to respond?
Well, what has been read out, what the previous reporter said, no problem with that. I would suggest in the core documents, document is this? This is the EIA report, volume 3A. There's a figure 7.48. which might be helpful. It shows the cumulative ZTV of Hollistan 2 and Limekiln 2 centred on the wildland areas. And you can see that northeastern, sorry, I'll wait for people to get that.
CD 1.4.
CD 1.4.
What was the figure number?
7.48.
You got that, Mr. Finlay? Yeah.
Okay. So in the blue area, you can see the blue shading for the ZTV in the sort of north eastern portion of the ZTV is the visibility or theoretical visibility of Limekiln 2, and you can see that extends in patches covering a good half of the wildlands area 39. There's obviously variability in the theoretical visibility cross that. This ZTV just counts, is it visible or is it not visible, rather than how many turbines are visible. And it takes account of visibility, theoretical visibility to blade tip. But that northeastern area there, where we're talking about the sensitivity or the susceptibility of the wildland qualities in that northeastern area, it is interesting to point out that from that ridgeline, from the viewpoint D, and looking across that area, the sensitivity or the susceptibility of that area was already somewhat reduced. And the reporters do refer to it as almost being transitional, that as you approach from the north, past the Hellstretta path, the core path, heading south, you are coming through the wildland boundary and through this transitional area into the wildland. And you're able to see all manner of things, including nuclear power station at REAY, which would indicate to you that you're not really in the wildland, even though you are. Lots of commercial forestry, and you have to sort of walk some distance through that strath and up onto the ridgeline and over into the wildland in order to sort of be able to experience stronger or more susceptible wildland qualities. And then just to go back to the point about terminology, we also have a matrix, which is, again, part of the GLVIA process. And once we combine the magnitude of effect with the sensitivity or the susceptibility, that gives us a level of effect and ultimately an indication of whether that effect should be significant. And just one thing that I would like to point out, in Nature Scott's assessment, for example, on wildland quality 2, they have deduced that the sensitivity is assessed as medium, reducing it from high, and the magnitude is assessed as moderate. now, if you apply to the matrix a moderate sensitivity magnitude and a medium sensitivity, you get a moderate level of effect. But what Nature Scott appear to have done here is that they've said they deduce a major or substantial effect, which they call significant. Now, there's no difference between us in the sense that for taking account of Limekiln 2, we also conclude a significant effect, but there's just this sort of nuance that Nature Scotland have gone that step further there. There's sort of higher rung of the ladder, as it were, in defining that effect as major or substantial, whereas our matrix would sort of compute that as a moderate, although significant effect, or a major, moderate, and significant effect. You're on mute.
Thank you. Ms. Harry, do you want to respond?
Yes, so the first point about, I think we're really talking about sub-area 2 when Ms. Rylett was describing how the susceptibility of the area to the east of the Ben Rather Ridge would be reduced, which we're in agreement with. It's been influenced by external factors. We're in agreement with that. I think I would dispute whether you feel like you're in the wildland area or not, but that's probably by the by. But that area to the east is not the primary area that we are concerned about with regards to the Drumhollistan proposal. Whilst there is a contribution clearly of that area is important, it's about the areas further into the interior, which may stray into your next question. To the west of that ridge line, with regards to the setting of where significant effects are concluded, medium and a moderate, it's down to professional judgment. I don't think I think this is, it's not a huge amount of value perhaps to go into the detail of where the terms have been used. I think there's we have taken the view that yes, sometimes a medium and moderate can be, I know we're both in agreement anyway with significant effects on that area. So I think that's all I need to come back with. Can I just double check? I've got a lot of noise outside. Can I check that nobody can hear that noise outside? That's fine. Good.
Okay. I'm happy that we leave that there. I understand. I mean, overall, the parties are saying this a significant effect. I get the difference in terminology. Ms. Ryan, is there anything else you want to just?
Yes, sorry, just point of clarification. Ms. Harry was referring to sub-area 2 there, which I think is perhaps what the previous reporters defined it. And I just wanted to be clear on this. I've got the northeast sub-area, and then I've got sub-area 1, which I've referred to as the northwest area. Then I've got sub-area 2, which is around Loch Nanoon. And then I've got everything else, which is sub-area 3. Sorry, sub-area 4. No, I beg your pardon. Sorry, I'm please just disregard that. Miss Harry was correct. Okay, sorry.
I think that tells me it might be useful to have a short comfort break for everyone. It's 25 to 12. How about we break until 11:45? 10 minutes, give her a slight break from the screens and come back. When you leave, just put your microphones on mute if they're not already on mute. Switch your cameras off, but don't leave the call. And then when we come back at 11:45, just switch your cameras on and we'll start from there.
Thank you.
Okay. Thank you. Okay, thank you. I think we're all back now. I think we can go on to question 8 of the agenda, which probably leads on again from where we just finished our discussion just before the break. And I've just said there that in relation to wildland quality 1, Nature's got concluded there would be significant effects on the appreciation of this quality, principally in the northern part of the wildland area within around 8 to 10 kilometres of the proposal. And I guess this is coming back to the point about looking at the whole of wildland area. I just wondered where within the area would the effects be most significant, and even if the geographical extent of the significant effects is not as widespread as suggested by Nature Scott, which is one of the criticisms from the appellant, would it still be significant in Nature Scott's view? So, Ms. Harry, I'll come to you first on this one.
Thank you. Where we've identified significant effects, broadly aligned with the applicant's sub-area 1, which is the northwest of the Benrath Ridge, sub-area 2, which is northeast of the Benrath Ridge, and sub-areas 3 into the interior. We've not tried to pin down exact locations where effects would be significant. That's more akin to a visual impact assessment, although these effects are demonstrated by EIA viewpoint B, which is the Lochanoon viewpoint that we've been to already today. So where here turbines appear to overwhelm the small knolly coastal hills and are more comparable to the distinct top of Benratha Ridge. So we feel it's helpful to, when considering wildland, whilst using areas, locations or viewpoints as proxies to illustrate a particular experience, recognising it needs to be augmented by fieldwork. So really, wildland is best considered in a similar way to how you might consider landscape character, or how that might be assessed, because that deals with the effect of a change on a landscape resource, including its characteristics and perceptual aspects, as opposed to the views obtained by people, which is the primary consideration of visual effects.
So from that, it's looking, you don't want to pin it down because that detracts from the fact you're looking at a wider, I should say, landscape assessment, the impact on an area of land as opposed to the perception of a person. Okay, Ms. Rylott, do you want to come in on this one? Oh, you're on mute.
Sorry, another pound in the swear jar.
Yes, I would like to come back and provide my own answer to that. Could I ask you to get out document 1.4 and look at figures 7.46 and 7.47?
What's Finlay, have you got them? Yeah, so we're all good.
Okay. So to respond to Nature Scott first, yes, we agree broadly that the significant effects would be contained somewhere within sub-areas 1, 2 and 3 in respect of wildland quality number 1. And it's worth just remembering what that is, an awe-inspiring simplicity of landscape at a broad scale with strong horizontal emphasis, wide skies and few foci. So I think Ms. Harry referred to viewpoint B at Lochanoon, and if we can just look at that that viewpoint, I'm looking at figure 7.55, which is the photo montage of from Hollistan 2.
Yes, I've got that one. So
I think it's worth remembering that this viewpoint is a horizontal field of view of 53.5 degrees. So it's less than what you would see in the field. You would see more or less 90 degrees, twice the distance of this. And I just challenge a little bit the use of the term overwhelm the horizon there. And we've already noted that the horizontal extent of the effect on that view is 8 degrees. And also to then draw us away from the viewpoints and to consider standing in that position and experiencing the whole wildland and having the 360-degree experience of this wildland quality. And the idea that 10 degrees, 8 degrees equates to something like 3% of that 360-degree experience, spanning all around in all directions. And yes, from that location, you would be able to see parts of Limekiln 2 and other wind farms in the distance and other features. But for me, even with Limekiln 2, the revised baseline, and the revised Drumhollistan 2, having that 360-degree experience, I still believe that there is a strong sense of wildland quality number 1 remaining. And then if we refer to the ZTVs that I asked you to look at, we look at figure 7.46. This shows us a ZTV to blade tip. And in the viewpoint that we've just looked at, you can see there are some blade tips. And their visibility and the magnitude of effect of the blade tip on the horizon, although noticeable, although present and having an effect on the wildland, it's far less than being able to see the hub and some of the towers. Now, if you compare that ZTV over the page, and it's quite easy to sort of flick between the two, you can see how the ZTV fragments when we look at the the hub height ZTV on figure 7.47. And if you flick between the two, you can see that. And if you look on the key, you can see the change in the colours between blue, red and yellow is represented being able to see 1 or 2 turbine tips or 1 or 2 turbine hubs, 3 or 4 turbine tips or hubs, and 5 to 7 turbine tips or hubs. And so I think, you know, in a sort of very crude fashion, in addition to looking at these visualizations and looking at the wireline, looking at the ZTV, you can see certainly on figure 7.47, you can almost map it out. The area in yellow next to viewpoint B, and then the area in red around viewpoint B is one sort of area where I feel that there would be some significant effects. And then you have to combine that with your experience in the field, walking through that landscape and recognizing that as you go up and down through the undulations, you're going to be able to experience more or less of this broad simplicity of this landscape and this strong horizontal emphasis. I don't know if that helps. I hope it helps in sort of trying to pin down the sort of extent a little bit more in terms of where the significant effects would be.
That is helpful. It's Harry. Do you want to respond?
Just on one point, I think it's to do with where Ms. Rylett took us to describing about the extent, as in the visual degrees of extent that you would see of the proposal. And I just feel that's slightly misleading because it's more akin to how you would assess visual effects. and I wouldn't disagree with any of the numbers that she's presenting with that, and about your experience in the 360 degrees, and I would agree that is important, but I think it's about, it's not about how much of your view is affected, which might be a consideration for visual effects, going back to how one of the previous questions, how we assess effects on wild land. We're considering what is the change in that landscape experience.
I think it's fair to say that the use of the term field of view or horizontal field of view, or even indeed vertical field of view, is just one of the tools that we have to help us describe the extent of the effects, or the geographical extent of the effects, or the extent of the magnitude. Distance is another.
Ms. Harry, just taking you back to figure 7.47, and what was Ryle said about the significance. It's kind of, you can see the red and the yellow around B. Would you agree that's where it's most significant, the impact?
I think I wouldn't want to go down that route, because I think what we're doing here is splitting hairs between when you can see a hub or not. That's the difference between 7.47 and 7.46. So whilst what 7.47 is telling you is where do you see a hub of a turbine and above, and I don't think because you don't see the hub and you see a blade, that is necessarily diminishing the degree of effect. So in this instance, in this particular wildland area, where the overarching quality that we've been looking at is about this simplicity, it could be very little of a tip that would make a difference. It's the fact that you see something that is an obvious human artifact that's important. So I would say no.
You're coming back to the point. It's about the impact on the quality in the field of the landscape, as opposed to what you visually can see from a point.
Yes, that's correct. Yes.
Michelle?
Yes, it may be just worth adding to that that these descriptors, the ZTV, the horizontal field of view, whether it's a tip, whether it's a hub, they are objective facts, and it's important to bring those into the assessment process, because we have touched on professional judgment here, and we're all taking subjective professional judgments on our experience of this wildland as well. So I think providing that just helps balance the assessment, that we've got some factual evidence and we've got some qualitative evidence from the field.
Okay, thank you. I think that's a fair point. Can we move on to question 9? I think someone did mention at some point the word dominant already today. If that was you, Ms. Harry, it was just to get views on whether you think the proposal is prominent or dominant, or maybe neither. I will start with the appellant, actually, this one.
Okay. Our view is set out in the rebuttal, CD 11.12, paragraph 1.2.2. It's the effects at the viewpoint are all prominent. It is only the closest views along the boundary of the wildland area where the effects are would perhaps be described as dominant, although one has to remember that standing in that sort of position at the edge of the wildland, the pylons would be overhead, and so there would be features in your foreground that would be even more dominant, and possibly other features as well. such as if you're on the Hellstrather path, then you would be a very short distance from the Limekiln 2 turbines. Now, the Wildland Guidance 2020 and 2017 promote the use of the GLBA approach. And you can see from our matrix, and you can see from the EIA report, and it's volume 4, Appendix 7.A, which is our methodology, which sets out our definitions for sensitivity, magnitude, and levels of effect. And that's where we've equated a high magnitude to a major change or obstruction of the view directly visible appearing as a dominant feature, and a medium magnitude as a prominent change to a partial to the view, and then so on. And I think over the page, we've got a low magnitude equating to a noticeable change in the level of the view, and so on. And so because we have defined our term, our definition of dominant and prominent, and we've used it consistently, and we would also like to point out that in the previous reporter's decision, and the paragraph numbers are 4.99 and 4.100, they also use the term prominent and not dominant in respect of Drumhollistan 1. I would suggest that the use of the term dominant implies an overbearing effect, where the turbines would be experienced at close proximity, and the previous reporters did use this term in reference to DH1 viewpoint from the lay-by on the A836. And that was in reference to DH2. They used it. DH1 that they used it. So the question, I suppose, is back to Nature Scotland to define their terms and to confirm, are they using the same terminology as us here, or do they mean a different dominant?
Tari?
Yes, thank you. I think that's helpful, and there's going to be a lot of areas where we're aligned here. So we've used both terms in our advice, as there are instances we feel that where the turbines are dominant, in that they would form the main focus of the view and would be so visually arresting that the viewer wouldn't appreciate other features clearly. So an example of that would be at viewpoint A, in our view, that Shanna Ray is an example of dominance. So conversely, there are other instances where the turbines would appear prominent, as they'd be eye-catching, but don't necessarily form the key focus. So I think our definitions are probably broadly in a line. So whilst they deflect attention away from other features, they wouldn't be the overarching feature. So we have concluded overall that where the turbines are seen in locations where there are significant effects, so we're talking about this north eastern area of the wildland, we have taken the view that they would be a dominant feature, and the reason is to do with the context. So as Ms. Rylett talked about already, it makes a difference what else is in the view. So I think I would disagree that actually on the boundary where you have pylons, there are in some ways they could be seen as less dominant when you're considering wild land, because you already have very large features that are close to your view. However, when you're within the wildland areas where the effects are significant into that interior, there is little else that's drawing your view. Therefore, we've concluded dominant, because if we go back to our definition, we think that they would become the main focus, given there's little else other than natural elements in the landscape. So hopefully that is clear, but I do appreciate we've used both terms and we haven't given a definition to those terms.
I think your explanation there is very clear to me. Charlotte, do you want to respond to that? Any comments on that?
Well, thank you, and it's helpful to have the definition of the term dominant and prominent, and it is slightly less than the terminology that we've used in terms of their meaning. because they've said the feature would be an arresting visual feature in the viewer. It would have an arresting effect, and it would be sufficient to detract or take the viewer's focus away from other features in the view almost exclusively. Looking at the viewpoint A, I wonder if that is completely true, because from that viewpoint, there are so many other features that are visible, and from that 360-degree view, you've got that amazing view to the south, where the wildland extends into other wildland areas and way across to the Lone Mountains, and then you've got the features along the northwest and the northeast of the coastline, including Limekiln 2 and successive wind farms. You can see Orkney, there's the sea, you know, there's just so much to look at. And I kind of look at this wind farm here and think that, well, yes, it would be prominent in that view. But I'm not sure that I would go so far as to say dominant, having heard Nature Scott's clarification of what they meant by that. And that's probably a difference between us.
Did I?
I don't think I have anything to add, because I think we've made our point on that one.
Yeah, I mean, there is a difference between you. And I can look at, obviously, I'd be on site, look at visualizations, and that'll be judgment we'll have to come to. Is there anything anyone else wants to add to that? No. Let's go on to question 10. And again, it was just to clarify my understanding that from the evidence before me, my understanding is that the significant adverse effects on the wildland qualities cannot be overcome by sighting design or other mitigation, on the basis that that's been done, and these are the residual impacts that are left, which are significant. Is that agreed? To my understanding, agreed that is the case? I can see Nature Scott nodding. Appellant, Ms. Rylott?
Yes, yes, we agree. We think there's been a number of iterations looked at between DH1 and DH2, and having had some overview of that during the process, I feel that there is a good degree of mitigation provided in DH2. I think if you were going to go any further, you would start to erode the benefits of the scheme.
I suppose on the basis in your mind, you'd either have to reduce the size of turbines or the number of turbines.
Yes, it's about the composition. It's about the appearance of it and its effect on the wildland qualities.
Okay, so I will go on to question 11. Maybe we've touched on this to a certain degree already, and this was the point about that absolute figure in relation to theoretical visibility across wildland area, whether that is important. And I think we've maybe touched on this, and I maybe don't need to go too much further on this point. It was that the fact that we refer to that there's been a reduction in that, and the appellant comments on that in relation to the various viewpoints. And I was just going on to think, is that figure important? And is it actually more important as to where the wind farm is visible or experienced from? So if you're in an area of where there's a high degree of remoteness and resulting in solitude and sanctuary, that is a key area, as opposed to what you can actually see is the feeling. And I would just say, would the impacts be experienced in areas where the wilderness qualities are currently strongly present? And just as a clear point, would the ability to experience that level of wilderness be lost altogether from wildland area 39? I'll start with Ms. Harry, and maybe you kind of cover some of these points, but if you want to give your response to that, then I'll go on to Ms. Rylott.
Yes, an absolute percentage of the degree of theoretical visibility across a wildland area is not necessarily helpful, in our view, in determining the significance of effect. Some wildland assessments include this, but it can be a distraction as there's no threshold over which the effects are considered to be significant. Where effects are greatest is an important factor, as you say. This helps to identify the degree of erosion of a particular quality. If, for example, a quality is only weakly expressed, say at the margins of an area, then it might be the case that its susceptibility, which we touched on before, to further change is reasonably low. Where wildland qualities are strongly expressed, this will be reflected in their overall sensitivity. So the impacts of Hollistan are across areas of high wildness, such as the interior, so area 1 and 3, and whilst there would continue to be some experience of the qualities from these areas, these would be very much diminished. Developments such as Hollistan outside of wildland areas can erode the strength of qualities. And whilst some erosion may be accepted, we of course accept that landscapes inherently change. There will be a tipping point where the incremental erosion might put into question the validity of the wildland resource. And this is the case for this proposal in our view.
So do you think the built experience, the level of wilderness, would be lost altogether or just diminished to such a point that it's not strong enough anymore? Just to phrase that.
Yeah, I mean, it's a difficult one because we don't have a mechanism to remove this wildland area from the wildland mapping. Of course, we have it in our policy. In Scottish planning policy, it's referred to the map, which is the wildland area map, of which Wildlander 39 is part of. So we don't have that mechanism to say that wildland area wouldn't exist anymore, for example. But I think one way that we could respond to that would be by saying, should this development go ahead, it may be that the qualities would be lessened to such a degree that we wouldn't put the value on the area that it has currently. And I think that's the critical point here, which is consistent with how we address this in the first inquiry, both in our conclusions for Limekiln 2 and Hollistan 1.
I just see Mr. Kelly coming with his hand, so I'll go to Mr. Kelly on this because it kind of links to the next point in the agenda about the straw that breaks the camel's back, which came out with the dialogue hearing statements. Mr. Kelly, do you want to comment?
Yes, obviously RAWOG is on the same side as Nature Scott here, but just in responding to what Ms. Harry said, the wildland areas are mapped areas, and they were defined by a mapped-based assessment. And in the 2014 guidance to ministers, the then SNH explained carefully and rebutted the criticism that was put to them as to how they mapped the wildland areas, taking account of the existence of wind farms that had been built and wind farms that had been consented but not built. And as far as we are aware, and as Ms. Harry will know, it's been done in other cases, you can remap the wildland areas with all the wind farms in place. And RAWOG's view is, and again, we're very careful here not to disagree with the conclusions that Nature Scott reached, but RAWOG's view is that is a useful supplement to the highly subjective approach. The subjective approach relying on professional judgment might work when you're standing at a wildland viewpoint thinking about one wind farm. But when you're standing at that wildland viewpoint and trying to think about the effects of, I think it's 8 or 9 wind farms, the majority of which haven't been built yet, I think it's impossible to intellectually compute that through simply professional judgment. So, simple point is the effects on the extent of the wildland can be mapped. If I can, perhaps, ma'am, just to say everything in one go, switch to paragraph item 12 in the agenda. The RAWOG concern here is salami slicing. Since you have put this session in place, we now also have what we call the Strathy Wall fully in place. Strathy Wood has been consented by Scottish ministers, and Strathy South, with its 200-metre tall turbines, has been consented by Scottish ministers. So the cumulative position in terms of the effects on this wildland area are changing every day. Sadly, in both those other cases, in one case the reporter and the other case the ministers refused our request to seek up-to-date cumulative advice from Nature Scot in terms of the wildland. So I'm very careful not to go into policy issues, ma'am, but from RAWOG's position, it's the whole of the wildland area that is protected by virtue of SPP2, and salami slicing simply, in our view, undermines that protection. Thank you, ma'am.
Thank you. I'll ask Ms. Harris come back on those points, and then I'll go to Ms. Rowlett.
I absolutely would agree that it's not that it can't be remapped. Absolutely, this is a mechanism that, given time and resources, of course, this can be done. So I think the point I was making is that the current map that we have, the 2014 map, is embedded in our current policy. So even if we remapped it, it would have no status. So it was more about that. That's what I was implying by mechanism of approach. And because the 2040 map is what we're all looking to, that was my point about that. I don't think there's anything else that I need to come back on, unless Mr. Findlay wants to come in at this point.
Okay, I'll go to Ms. Rowlett then at this point.
Thank you. If I could just take us through question 11 in some parts there, because there's a lot of discussion there to respond to. The first part was in relation to theoretical visibility across the wildland area. Is an absolute figure important, like the wildland affects 10% or 15% of the whole area? And I have to say, I agree with Nature Scot that that the ZTV is a starting point. As I said earlier, it is useful to provide some objective information about where we're going to see the wind farm from and how many turbines we're going to see. We can draw some preliminary conclusions from it. It can help us define where the significant effects are likely to be, but it does not map significant effects. And so certainly, in my view, that the significant effects, were we able to map them, they would be far less than the pattern of ZTV that we see. Also, I'd like to talk about when we come on to remoteness and solitude and retaining high degrees of these wildland qualities, it's worth looking, if we can still flick through to figure 7.45 in the EIA report. To go back to the beginning, because RAWOG have brought this up, and to look at the overall character of this particular wildland, and to remember that nature's policy and approach to mapping wildland is not to claim that we have areas of wildness or wilderness or extreme wilderness areas. It is wild land, and it accepts that these are areas that you can draw a line around and identify or map, but it's not to say that other features are not going to be visible beyond their boundaries. And this is clearly expressed, perhaps because of the character of this landscape, the sweeping moorland that you are able to see across it, that it can appear bigger than it is, and that you can consequently see features that are beyond its boundary. And you can see that the character of this wildland area on this ZTV, we've got in blue existing consented turbines, maybe theoretically visible. Now, some of them are going to be a long way away, some of them are going to be much closer. It depends where you are in the wildland, which wind farm is you are closest to. But there is a characteristic, and having walked across this wildland from the north all the way through to the south, and from the east all the way through to the west, and vice versa, you do constantly see there is a theme of wind farm development that runs alongside this. And I would also add to that that perhaps one of the things to bear in mind is CD 5.22, if we can get that out, which is the description of the wildland. And when Nature Scholars are talking about, you know, and the possibility that if we carry on consenting wind farm development, it will diminish the point where it no longer is wildland, and references to salami slicing, I would say to you, you know, if you're in the wildland, and we're talking about development that is out with the wildland, if you're in the wildland and you experience the wildland as it's described here, and you could read through this, look at the pictures in it, and ask yourself, are these special qualities still apparent? And I think, sorry, am I getting some feedback there? I think when you read through that description and you go back to site and look at the quality of the wildland and remember the 360-degree experience, and not just the 360-degree experience from a particular viewpoint, but the journey that one takes crossing the wildland and travelling through it and being immersed in it, that I think there is a great deal still to be given from this landscape, and the fact that there are no wind farm developments within its boundary is hugely important to that. And I would also add that when we look at other wind farm developments, we've had reference to the Strathy schemes and also Limekiln 2. Hollistan 2 affects the northern area in common with other wind farm developments and other human developments. And I would suggest that it is somewhat a smaller slice of the salami, perhaps a slither. Please, can you let me know if I've answered that question 11, or if there's any parts of that question that you'd like me to expand on, because I think it's broken into 3 parts.
I think between what you answered there and your previous answer, you've covered it. Just going back to the point there, maybe about with the impacts we experience in areas where the wilderness qualities are currently strongly present. Do you think that's the case?
I'm sorry, could you repeat that, please?
Yeah, would the impact be experienced in the areas where the wilderness qualities are currently strongly present?
Yes, I believe that those areas, I think certainly where you go to Viewpoint B and Loch Lanoon, there is a strong, the wildland qualities there are strong. I think when you go to Viewpoint A and you're on the ridgeline there, I think there is a weakening of the wildland qualities there. They're not as strong. And when you go to Viewpoint E and you go further to the south east of Viewpoint E, so somewhat deeper into that wildland, you have to remember that all along that boundary, probably for a good kilometre or so into it, the strength of the wildland quality is not as strong as it would be from deeper within it. And so I think there is a variation. And so there will be some instances where the wind farm affects the wildland qualities that are weaker, and some areas where it affects wildland qualities where they are stronger. It does not affect the experience of being able to stand in that wildland or look across it to the south, however, and see this join up with multiple wildland all the way across to the Lone Mountains.
Thank you, that's helpful. Ms. Harry, do you want to respond or comment?
Just as a point of clarification, it wasn't Nature Scott who mentioned the salami slicing. I think there was just a reference there. It was just to be clear. And also, are we just dealing with question 11? We haven't moved on to 12 yet. Is that right?
We've touched on 12, but I'm happy for you to still deal with 12, because I'm not sure if Ms. Rylett's covered 12 or not. But you can, if you want to say anything on 12. I think we've probably done 11.
Yes.
On the basis I understand both parties' views on that. So yeah, I think come back to 12, because I think Mr. Kelly commented on 12 in the context he was going to cover all the points he wanted to make at that point. So yes, let's concentrate on 12 just now. Okay.
So I think just to be clear, we were clear on the position for this is about the further diminishment as a result of Limekiln 2. At the first inquiry. So we stated that either Drumholston 1 or Limekiln 2, if they were permitted, the wildland area would seriously compromise the value of this wildland area, being considered as one of the most extensive areas of high wildness of importance in the national context. And just to confirm, we still stand by that view. So we have continued to advise that Limekiln variation, which is CD 16 on page 5, this is our advice. There will be a cumulative effect with this proposal, that's Limekiln variation, and the Limekiln extension, Drumhollistan 2 and Akron, both individually and in combination, which will result in a further reduction in the strength of wildland quality 1, which is the one we've been discussing, and wildland quality 2. These cumulative effects are not considered to be materially greater than those already experienced as a result of the consented Limekiln scheme in combination with the same wind farm proposals. So when considering the effects on the wildland area as a whole, or integrity as we've touched on earlier, the subsequent lowering of susceptibility of wildland qualities, which is a direct result of Limekiln 2, which we've already described, means that whilst the wildland area qualities can be still be experienced, they are very vulnerable now to further attrition. So we are in agreement with RAWOG that Drumhollistan 2, should that gain consent, then the wildland area would be seriously compromised and may not merit inclusion as one of the most extensive areas of wildness, which, as I said, this was what we said at the first inquiry and within our hearing statement. Whilst the wildland area has been eroded, we do still consider its qualities are currently expressed sufficiently for it to be considered meriting inclusion as a wildland area. But the additional effect of Drumhollistan 2 would bring into question that merit. So whilst there's no mechanism for modifying the wildland areas themselves, there would be serious questions to ask about the validity of wildland area 39 as a result. So as you have put it, perhaps the integrity could not be maintained. So in contrast, and just for balance, we advised in our response to the Akron wind farm, which is CD 611, that whilst the effects of the Akron proposal on wildland 39 would be very similar to Drumhollistan 2, were Drumhollistan 2 consented, there would be little additional harm to the qualities as a result, an additional result, that is, of Akron. So in effect, it would be Drumhollistan 2 that would be the straw, as RAWOG has put it.
Ms. Rowlett.
If perhaps I could just jump in with a continuation of the camel metaphor, and I guess one aspect of this hearing that, you know, as is clear the applicant thinks is important, is that we do have the benefit of the previous detailed inquiry session on wildland and the reporter's previous report. And of course, that was a conjoined inquiry with Limekiln. So we do have the benefit of the assessment of the whole bale of hay, if you like, because that was a consideration of Limekiln and Drumhollistan together. So it's not a case that we are thinking for the first time about the additional straw or slither of salami or whatever of Drumhollistan. The whole sausage or whole bale of hay was considered the first time around.
Seems right.
I don't think I have anything further to add other than to say, we have not assessed the Akron scheme. And I think if there's a continuum between DH1 and DH2, it's clearly our position that DH2 is a scheme that has had the mitigation provided. But I'd also remind you of the Doon-Ray Try development, which is offshore. And I believe that Nature Scott have not objected to that, and that would also be visible across the wildland, roughly aligning. I think you can see it in the wire lines with views of DH2. So there would be an intrusion potentially from an offshore scheme.
Sorry, do you want to comment on?
I don't take any issue with what's been said there.
Just coming back to you just on one point. Obviously, Limekiln 2 was consented, so it is a different baseline, albeit they were both considered in a conjoined inquiry previously. But Limekiln 2 is part of the baseline. Do you think that if you accept that diminishes the quality of the wildland area, do you think that, or do you accept that it's then easier for it to be eroded more through Drumhollistan 2? So it's a kind of a lower bar.
It's not the approach that I've taken, but we do recognise in our cumulative assessment an increase in the level of effect, because although I understand it's under construction, Limekiln 2 is not existing or operating, should I say. So when we compare our assessments of DH2 with the baseline of existing wind farms, we get one level of effect. And then when we add to that Limekiln 2, I generally find an increase in the level of effect. So I don't think that I'm guilty of subtracting Limekiln 2 or trying to make the path easier in terms of assessment.
But if integrity has been already diminished or eroded to a certain extent, does it follow that the introduction of this scheme, if it was consented, it's easier for it to tip the balance, even though it's a smaller scheme?
I mean, I think our case is not, and doesn't rest on the fact that Limekiln 2 has already been authorised and so has diminished the susceptibility It's not a case that we're saying, well, the damage has been done by Limekiln, so you may as well also consent Drumhollistan 2. That's not our primary case. Our primary case is that the impacts of Drumhollistan and Limekiln cumulatively weighed in the planning balance aren't enough to outweigh the substantial renewable energy benefits. That's our primary case. It's not a case of the damage is done.
Does it follow that because you could argue there's been a diminution in qualities, that something that may have been acceptable may no longer be acceptable because there's less quality to protect?
Well, again, I guess just logically, if cumulatively the two schemes together were acceptable previously, then consenting them sort of sequentially one after another rather than at the same time shouldn't make any difference to the end result, which was if they were both okay last time, they should both be okay this time. I mean, that's a very simplistic way of describing it, but that's the general gist.
Another way of looking at it, and sometimes it's approached this way in assessments, that with increasing development, the special quality becomes more sensitive, not less sensitive, because the whole purpose is to be preserving it. Whilst one might go away and measure or reevaluate the wildland area to check, is it still wild? The sensitivity could become higher as increasing development comes. And I take the analogy with the Ochils, the AGLV area of Great Landscape Values. That one has had a series of wind farm developments built upon it. Every time I've been involved with an assessment of that, we've taken the approach that the sensitivity, because of cumulative development, tends to increase, not the other way around. And ultimately, the landscape designations, local landscape designations, are subject to regular review. The Ochils was subject to a review not so many years ago, after a number of wind farms had been built within it. And the authors, independently of any assessment, concluded that the special qualities there were still strong enough, despite wind farm development within its boundary, that it should still retain its designation. And I think whilst accepting wildlands is not a landscape designation, there is a parallel there to the approach that can be taken.
That's helpful. H.R. Scott, do you want to respond to that before I move on?
Yes, I think this probably ties quite well into question 14, because I understood the question with regards to cumulative effects primarily with regards to Limekiln, I must admit. But so the baseline being the consented Limekiln 2, we think is critical in understanding the subsequent effect that Drumhollistan 2 will then have, and the difference between that and Drumhollistan 1. I take issue with where it was referenced that both developments were okay at the time. I think that was maybe the phrase used. I don't think they were, because clearly Drumhollistan was refused the first time around. So I just wanted to go back on that. So the addition of Drumhollistan 2 to that baseline would, in our view, be a significant cumulative effect. I think we need to be careful about the term cumulative, but maybe not get distracted about that here, or significant additional effect, we could say. So whilst it's recognised by the applicant in their wildland assessment That's para 1.5.5.3 at Appendix 7D. I think our point is that we don't think it's been given due recognition in the overall consideration of effects. So where the applicant summarises the effects in para 1.6, so that's that is the same document, isn't it? At the end of digital page 14, I've put, I wonder if that's CD 1.7. Sorry, let me just double check that's the same document, so I'm not taking you to a different document. Yes, that is the same document. Okay, so that's a wildland assessment. Consideration of cumulative effects. This is what the applicant's summary is stating. Primarily in relation to Limekiln 2, the addition of this wind farm would further reinforce the baseline strength/weakness of wildland qualities, with reductions in the strength of wildland quality affecting the Ben-Ra ridgeline and intervening land in particular. This would not alter the Drumholston 2 assessment. Rather, it reinforces or overlaps with the premise that Drumholston 2 would often be viewed in the context of other wind farm development and land use, particularly from the Ben-Ra ridgeline. Limekiln 2 would not be visible from the northwestern corner and would not cumulatively affect this part of Wildland Area 39 that would be additionally affected by Drumholston 2. So the cumulative ZTV might be useful here. If we go back to that same ZTV we've been to, which is figure CD 1.4, figure 7.48 again. So as we've been through, this illustrates the combined visibility of Drumholston 2 and Limekiln 2. So green, we've been through what the various colours mean. So it's noticed that areas to the east of the Ben-Ra ridgeline in sub-area 1 have far greater visibility, obviously, of Limekiln 1. We know that, Limekiln 2. We know that, with less visibility from Drumholston 2. So we take from that above statement that I read out from the applicant that they consider, whilst the susceptibility of wildland qualities has been reduced as a result of Limekiln 2, Drumholston 2 would have less of an effect on those same qualities than if Limekiln 2 was not there. And I think that's the bit that we're not in agreement with. So we think it is very important that Limekiln 2 is considered fully, because it is a consented development now. So where the applicant's wildland hearing statement at para 5.1.7 states, taking account of revised cumulative baseline as well as the design revisions made to Drumholston 2, the previous reporter's judgments that the effects on wildland area 39 would not be sufficient to affect the wildland integrity should still logically apply. And I think that's the bit that we don't agree with, that presumption that conclusion is carried over into this proposal. So whether these effects are termed cumulative or not, I don't think is the issue. The difference in view appears to be that if the addition of Hollistan 2 to Limekiln 2 is significant in terms of the effect on the whole, and we consider it is. So sorry, that was a lot of references there. I hope that makes sense. You're on mute.
Sorry, I knew it would happen at some point. I guess it comes back to that point whether you take the view that the wildland qualities are less or more susceptible to being affected because of Limekiln 2. Sorry, do you want to comment? The time is 1:45, so I think we can continue, or
I think you've gone back onto mute, if I can.
sorry, I don't know how that happened. I just noticed the time, it's 1:45. We're kind of on questions 12, 13, 14 at the moment. We've still got 15 and then concluding remarks. Would parties rather stop now for a break or continue? I'm happy to go with the consensus.
Personally, I'd rather continue, but and I see Ms. Harry nodding too. I think we're, Mr. Kelly.
Continue. Appellant?
I think we had a feeling that a quick break might be nice for comfort, if nothing else.
A quick?
At least a break, yes. Yeah, 10 or 15 minutes.
We'll break till 5 to 1 then. We'll come back and hopefully wrap up in maybe half an hour or so. Does that sound okay? Or would parties prefer to have a lunch break? I don't mind either way.
That would be perfect for us. Just a 10-minute comfort break, thank you.
Yeah.
So to friendly, Ms. Hannah, are you happy with that?
Yes.
I didn't quite catch the time. Sorry, it was a bit of interference.
It's 5 to 1. Okay, let's do that. We'll break till 5 to 1 and then we'll come back and hopefully finish off relatively quickly. Again, just mute your mics and switch your cameras off. Okay, welcome back, everyone. We finished there with Ms. Harry just commenting on, I suppose, the impact of landfills as being part of the baseline and what we take from that. Now we'll look at Drumhollistan 2. Ms. Ryle, I'll come to you to respond to that because we've heard from Ms. Harry's view on that. Do you want to comment on that?
Well, you know, I think I can only reiterate what I said in a previous answer when I held up the wildland citation, and I asked you to look at the photographs in there and read the description and remember how you experience the wildland and the dramatic views to the south, the special qualities that are palpable all around you when you're walking through the wildland, and that, you know, our assessment takes account of Limekiln 2, as does that of the previous reporter. You know, we come to the view or the conclusion, however you want to phrase it, that the integrity would still be preserved with the addition of Drumhollistan 2. And I think, you know, we've got about 360-degree experience and how you experience this on the ground that is key to that.
So do you think there's any difference between assessing Drumhollistan 1 and Limekiln 2 when they're part of the conjoined inquiry? Is there any difference in that assessment to the assessment now of having Limekiln in the baseline and adding Drumhollistan in? So, in your view, do you I suppose agree with the view that if it was okay then, it must be okay now?
Essentially, yes. What we're looking at is a change in status. So previously, Limekiln 2 was included in the assessment as another application, and now we're looking at the assessment afresh with Limekiln 2 as a consented, though partly under construction, wind farm. So its status has changed. It has changed, and we've also taken account of the Limekiln variation and the Limekiln extension as applications.
And then come back to the point that you made that if you increase development, a resource can become more susceptible. Could that be the case here?
Yes, it could be the case here, but you would still look at the strength of the wildland qualities and determine that they may be weakened as a result of other development, and ergo their sensitivity of what remains is increased. That is an approach that could be taken, yes.
Okay, Ms. Harry, do you want to have any final comments on that?
Only one point that I think that we wouldn't agree about the assessments being the same with the previous when you're including Limekiln 2, because the weight to be given to Limekiln 2 has changed. It was in planning and now it is a consented development. So I think that is a material change in the consideration.
And I did recognise that change in her evidence. I thought that was a change. She recognised that it was originally another action and now it's consented or partially constructed. But I assume she's taken account of that change in status. But maybe Ms. Ryle can just confirm.
Yes, we did. Yes.
And just on that, I'm assuming, Ms. Ryle, your position would be that you have properly assessed the cumulative or additional impacts. I would refuse to suggest that there's been an under-assessment.
No, we've assessed and you know, and I can go through this at length, but we have tables in the environmental statement in the main chapter 7, table 7.3, lists the cumulative baseline that was assessed then. That was then updated in the EIA document in table 7.1. There's another table tells us quite clearly what projects have been included in the assessment, and then I've made further reference to this in the hearing statement. And as you read through my assessment, you can see there's regular subheadings in the conclusion tables and in the report that talk about cumulative, both in additional terms and in combination terms. So I think we've followed the guidance from Nature Scott on cumulative assessment of wind farms pretty thoroughly.
And Ms. Harry, from your perspective, is really the crux of it is how you deal with lime kilns, whether, in your view, you've got to assess it as a baseline, therefore things become more sensitive, therefore less acceptable. And I think that's the crux of the differences between the two parties. Is that fair?
I think that's fair, yes.
Could I just perhaps question that? It sounded to me, it's perhaps not more the difference between the parties, what the overall impact, the overall cumulative impact on the wildland area is. And the appellant's position is that the integrity, if you want to call it that, is not compromised. And Ms. Harry's position was that, not using the term integrity, but that the wildland area would be undermined. And so it's the overall conclusion as to whether or not the wildland area is sort of seriously compromised or not. That is the key difference between the parties, as I read it or heard it.
Ms. Harry?
Yes, I think you're right. That is the difference, and whether that's down to the additional effect of Drumhollistan on, in addition to the baseline. I think that's probably what we're trying to tease out here, isn't it? Is how much damage has been done to date, or will be, assuming Limekiln 2 is fully constructed, and the additional effects. So I think that's the integrity, for another word, is the next step to that. So maybe it was just taking it back a little. I'm not looking to confuse matters. I'm just looking to kind of ensure we've got clarity. So I think you're right. We are in agreement. Sorry, but we're not in agreement, obviously, about the effect on the whole.
As to what the key matter is, I think, Mr. Hutchinson, it's gone back a step. I think the point I was trying to make was one of the reasons for the difference in overall conclusion is how potentially Limekiln 2 is being taken into account. And that then leads to the parties having a different view as to whether integrity is compromised or not. But it's your overall conclusion that the parties are differing. That's very clear.
Although the overall conclusion was the same when the two schemes were assessed in a conjoined basis. So the Nature Scott conclusion was the same at the first inquiry, that there would be the wildland would be seriously compromised, and it's sort of word for word the same conclusion this time around. So the end result of comparing, of looking at the cumulative effect of Limekiln and Drumhollistan, the advice before you, ma'am, from Nature Scott is the same for when the two schemes were both at application stage and considered in a conjoined inquiry, and now when one is consented and one is still at application stage. So the overall advice in front of you is the same. Nature Scott consider wildland area seriously compromised, and the appellant considers not so.
I think it's also worth.
Sorry.
It's also worth adding that Nature Scott and ourselves have both taken account of Limekiln 2, and we may have approached it slightly differently in the detail of the assessment. but I would guard against double counting, i.e. taking account of Limekiln 2 as part of the sensitivity calculation as well as the magnitude calculation. And I think, between the two assessments, both parties have taken account of Limekiln 2, and that's that I think is the important point.
Okay, any final comments on that? No. I was going to go back to question 13. I don't think we have dealt with that one. 12 and 14 kind of merged in together. I think this came out of from the appellant's statement in rebuttal about whether Nature's got to take a consistent approach. I think there was a view that they had been inconsistent. Do you want to comment on that first, either Ms. Hutchison or Ms. Rylett? Or based on what you've heard today, are you more comfortable with what SNH have done?
I think that what we were trying to get at was looking at the Strathy South variation and seeing that was 39 turbines, 200 metres to blade tip, 9.8 kilometres distance away from the Loch Nanoon viewpoint, overlapping with views of distant mountains, and comparing that to DH2, 7 turbines, much smaller height, approximately 8 kilometres distance, affecting roughly half the horizontal field of view, to use the objective facts. And Nature Scott's response that the Strathy South variation resulted in no material change to the wildland area and no issues of national interest, whereas with DH2 they did. Now, appreciate that's just an example of one viewpoint, and maybe that is the answer, but that was the kind of thing that we were getting at.
Okay, I'll let the Terry comment.
No, that's fine. I mean, we're very confident that we always take to the best of our knowledge a consistent approach in these instances. We have a small team of advisors that speak with each other, and with regards to the Strathy proposal, the key issue here is about context. So the context of Strathy South is very different to the context from Hollistan 2, and we have assessed both those proposals in the same way, and whether we reach different conclusions, we're fully able to stand by those judgments and the advice. And the key about the material change reference is about meeting that national interest threshold. So as we've already advised today, it's about not all effects may meet that threshold. And in the case of Strathy South and its various iterations, it did not in the case of wildland.
Okay, I don't think I need to take that point much further. I think, Mr. Kelly, did you want to comment? I've just seen you come on the screen.
Yeah, yes, ma'am. We have quite severe concerns about inconsistency, partly on the case of Nature Scott, though in fairness to them, looking at the Strathy Wood case, the reporter declined to actually ask them for an up-to-date assessment of the cumulative effects on wildland. But nonetheless, we see a slight strengthening of Nature Scott's position as set out in Akron. The inconsistency comes in many respects from the decisions of the Highland Council, but those are not matters before you. You have to determine this case, and therefore, even though we do see quite significant inconsistency, the position of RAWOG is it's not a matter you can actually specifically take into account in determining this case. Thank you, ma'am.
Okay, any final points on that one? No. Okay. Moving on to 15. And this was, I'll put to the appellant first and then Nature Scott, what regard I should have to the Akron application in relation to cumulative effects. So I'll put it to the appellant, Ms. Rylott, probably first, or Ms. Hutchison, I don't mind.
Yeah, I can pick this up because I've got the dates noted down. So we discussed at the second preliminary meeting when would be an appropriate cut-off date, and I think that's covered in the statement of agreed matters, and I think it was largely agreed at the meeting, but also in the minutes that the cut-off date was the date the appeal was made, so that was 4th December, and Akron would fall after that, having been submitted on later in December, 18th of December, validated on the 22nd of December. So I guess Akron falls after the cut-off date, and so an updated cumulative assessment, including Akron, wasn't requested or submitted. So that's not before us from the appellant. Now I think cut-off dates are something that's accepted in Nature Scott's guidance on assessment of cumulative wind farms, because there must naturally come a point where you stop assessing cumulatively new applications and make a decision on the scheme in hand. But of course, so long as Akron remains an application, then they will need to take into account the cumulative position and baseline, which includes Hollistan and everybody else. So there's no risk here of inappropriate development being approved. That's risk is not there.
Ms. Harry or Mr. Finlay?
Whilst we know the proposal is in planning, it does highlight the degree of interest in this particular part of Caithness for wind energy development. So whilst we have objected to the proposal for very similar reasons to the Hollistan proposal, we are mindful that we may need to review that advice if Hollistan gains consent prior to the determination of Akron. So we have considered the cumulative effects with Akron and the proposal at para 7.2 of our hearing statement, CD 10.2, but it would be difficult for yourself to consider this given that there isn't the cumulative assessment within the Hollistan 2 Hollistan 2 application. So for you, it's more difficult because you don't have that assessment within the information before you.
Mr. Kelly?
From RAWOG's perspective, we didn't expect any updating of the cumulative landscape and visual impact assessment. All we wanted to draw to your attention was the content of the Nature Scott response to Akron, and that is the only document we'd ask that you have regard to is the Nature Scott response. Just to confirm to the appellants, we absolutely did not seek any updating of the cumulative information.
And I've got that response, that's CD 611, which is Nature Scott's response. And it does, as you say, that Ms. Harry said that we will review this advice if the Hollistan 2 wind farm receives approval. Okay. Okay, so I'll now turn to any final concluding remarks from the parties. As I said at the start, this isn't your kind of final summing up, it's not your closing submission, so to speak. It's just if you felt there's a comment you'd like to make to some of the questions that you haven't had the opportunity to do so, then do that now, and then we'll come on to discuss the timescales for a written closing submission in due course. So, Mr. Kelly, is there anything final point you'd like to make that you think you haven't had a chance to say so far in response to the agenda?
No, man, everything's been covered, and no final remarks.
And then for Nature Scott.
I was just going to say, risk of adding new evidence, which is not my intent. I just thought it might be helpful to alert you to the Nature Scott webinar on wildland assessment, which is on our internet. So that might be a useful reference for you, but it's not intended that I have present new evidence to you, if you weren't already aware of it.
We are aware of it, but we try not to do things like that when we've got a live case on, because it could be construed as additional evidence that's not before the parties. So I might look at it at some point in the future when I don't have an informed case, but we are strictly encouraged by the Chief Reporter not to attend training seminars like that, which could add to your own view of a case and evidence, because there could be comments that come out of that, or an example used that's applicable to this case, which might not be before the parties. So in the interest of fairness and not to prejudice anyone, we don't do that if we've got a live case on. But thank you. I'm sure others might be really interested in it. And it's something we look at in the future. But thank you for referring to that. Appellant, Mr. Hutchison, Mrs. Rylott?
No, I don't think anything further, although the webinar sounds interesting. I'm sure we will attend as well.
Okay, so that's us at the end of the agenda, and that's really helpful. Clearly there are elements in dispute, but there's quite a lot of broad agreements and aspects for me to think about. So closing submissions, we did agree we'd have written closing submissions from the parties, and I was just looking at timescales, mindful of people's holidays coming up, Christmas period and New Year period, but also thinking of the fact that I suppose there's been a period.
I think you've gone on mute, ma'am.
Okay, I'm back now. Don't know where I got to, but think about closing submissions and the timescale for that. Being mindful of people's holidays. I'm not sure obviously when people are around during the next 2-3 weeks with the holiday period and Christmas and New Year and things like that. But also think about the fact you may have worked on your closing submissions since the hearings in September, October time. I would do it on the basis that the third parties, the Council of Nature Scott, would submit their closing submissions first, and the appellant would come shortly after. So can I canvass views on thinking about people's commitments, possible likely timescales for closing submissions? I've got an idea, but I'll just have a view as to people's commitments, bearing in mind the time of year. So, Mr. Kelly. Oh, you're just.
I'm just looking at my diary. I already have a request from the DPA for a submission on the 4th of January, which I thought was a public holiday. I then have the Garcroco appeal response on the 10th of January. I mean, it's not an enormous amount of work for RAWOG, but if it could be the 14th of January, that would be good. Excellent. If you wanted it at the start of that week on the 10th of January, then we would fit in. But basically, we will fit in with what the principal parties agree on.
Okay, thank you. Mr. Finlay.
Yeah, I don't want to put Mr. Kelly under undue pressure, but we're hoping to get ours done next week, if we can do so by sort of probably by Wednesday. If it's not done by Wednesday of next week, it will be after New Year. But that's our intention at the moment. So, to be fair to Mr. Kelly, an earlier date in January would suit us fine as well.
Ms. Bundy, for Caithness West Community Council, I don't know if you intended to submit a closing submission or just rest on the evidence you've provided so far, which you're quite entitled to do. You don't need to do a closing submission.
We will, thank you. We will probably submit a very short closing submission, and we are largely relying on the evidence of Highland Council and RAWOG, but we will certainly submit a short closing statement.
And from your perspective on kind of timescales?
Probably a preference for it to be after New Year rather than before, just with everything else that's happening. So into January would be ideal.
Okay, I'll get the appellant's views.
Well, I mean, it's been a long year for everybody, so the appellant doesn't want to put anyone under pressure to be drafting closing submissions when they could be spending time with their families over Christmas. So we're quite content to have a January date, and then the appellant to follow on, I don't know, 14 days after. Will you be that lenient, or 7 days, as you see?
I don't think I would be that lenient. Initially, I had actually thought in my notes the 10th of January for the council, Nature Scott, Caithness, West Queen's Council and RAWOG, and the 17th of January for the appellant. But Mr. Kelly, I don't want to put you in a difficult situation if that is going to be difficult for you.
I'm looking at the diary again. No, ma'am. We'll fit in with the 10th. We'll fit in with the 10th.
And would that suit everyone else? It gives you an extra 7 days for the appellant to do theirs. So if we go for that, then so the 10th of January for Council Nature Scott, RAWOG and Caithness West Queen's Council, and the 17th of January for the appellant. Okay, great. Okay, I think that's us at an end. Thank you all for participating today, and those who observed, thank you for observing today. Hope you found that of interest, and thanks for working a bit longer. Normally we say have a safe journey home, but you can never do that now. We're on virtual hearings. Have a great Christmas when it comes, and best wishes for the new year. Hope you can all spend some time with your families. And we'll no doubt be in touch with the case officer and my decision at some point next year. So you can all just leave the meeting and Callum will stop live feed.